I request all of you to please rise up for the Punjab University anthem. Today with immense joy and gratitude as we gather here on this beautiful morning. We have the privilege of welcoming an extraordinary legal luminary, someone whose relentless dedication to justice and advocacy has been a beacon of hope and progress for our society. We are honored to have with us today Senior Advocate Mr. Saurabh Kirpal, who has been at the forefront of groundbreaking legal battles, championing the cause of justice and fighting for equal rights. Mr. Kirpal's impressive career is defined not just by his exceptional legal prowess, but also by his unwavering commitment to promoting inclusivity and fairness. He has played a pivotal role in landmark cases that have paved the way for a far more equitable society, including the historic Navdeep Singh Jawahar case. His dedication to advocacy knows no bounds, and his unapologetic stand as an openly gay advocate has shattered stereotypes, setting an inspiring example for all of us. Sir studied physics at India's prestigious St. Stephen's College in Delhi. He then went on to pursue his law from University in Oxford on scholarship and later earned a master's degree from University of Cambridge. He worked with the United Nations in Geneva for a brief period of time in the 1990s. Since he returned to India, he has been practicing in the top court and has argued in several important cases. I must also express my heartfelt gratitude to someone who has made this event possible, our very own Professor Dr. Shruti Bedi ma'am. Her unwavering faith in me and the belief that I could coordinate this event is something I'll cherish eternally. It's her vision and support that have brought us all together here today. I would also like to extend a warm welcome and appreciation to all our esteemed dignitaries who have taken time out of their busy schedules to be a part of this event. Last but not least, I want to thank the students who have joined us with great enthusiasm on a Saturday morning. It is we, the next generation, who will carry them forward who will carry forward the torch of justice and equality. And Mr. Kirpal's insights today will undoubtedly serve as a source of inspiration for our journey ahead. So without any further ado, let us embark on this enlightening journey of knowledge and inspiration. Thank you for being here, and let us make this event a memorable one. I would like to call Professor Bedi and Professor Ratan to felicitate. Sorry. I would like to call Professor Bedi on dais for the opening address.
Good morning, everyone. It's a little cold and it's drizzling, but I'm so happy to see the turnout today and relieved. Because we have such an eminent personality here with us that it is actually a treasure that we are going to go through during the course of this morning. Ladies and gentlemen, Mr. Saurabh Kirpal, Senior Advocate, Supreme Court of India, our honored guest speaker for the interactive session with the students. Professor Ratan Singh, our former director of the University Institute of Legal Studies, and the inspiration behind all that is happening today in this institute. My dear faculty members who have all gathered here, I know the attraction, the pull was immense and you could not hold back and sit at home and enjoy your cup of tea on a Saturday morning at home. My other friends, Major Navdeep, Mr. Amit, Nicola, my former students who are here, in all their glory, it is such a pleasure to see them back home, as I would say. And of course, the very important, the audience, the students, the program is for you and it is by you. A great lawyer must possess excellence in skills, attitude, as well as dedication. Mr. Saurabh Kirpal, Senior Advocate, Supreme Court of India, the Don of Oxford and Cambridge, is the foot soldier of the Constitution of India. He is skilled, he is articulate, he is dedicated to the cause that he works for, and he speaks of perseverance as if it is something which is the most essential thing, and I agree. There is nothing more important than that. He possesses a deadly combination of knowledge, of wit, which we were just exposed to, clarity of thought and of expression, and the charisma of a Nobel laureate. Sir, it is indeed an honor, a pleasure, and a privilege to have you here with us this morning. Charles Dickens once said that if there were no bad people in the world, there would be no great lawyers. I would like to give it a little twist and say that if there were no issues of concern in the world, we would not have lawyers like Mr. Saurabh Kirpal. He is someone who calls himself an accidental activist. Reason? He began his practice as a corporate and a commercial lawyer, but stumbled upon the role of activism, which is evident in the fact that he led the lawyers, the team, in the very famous Navtej Johar case, which decriminalized homosexuality. And the more recent, and I believe the more important, equally important, the marriage equality case, pushing the boundaries, and actually giving meaning to what the courts have to do to play their role in protecting the rights of the people of this country. And that is exactly what we are gathered here to discuss. He has walked his talk. He has taken and pushed the contours of this constitution to open up its meaning and make the judiciary open its eyes towards the concerns of the people of this country today. The Supreme Court of India is known as the People's Court. It has worked tirelessly, it has worked ceaselessly to protect the rights of the people. Mr. Saurabh Kirpal has contributed to that immensely, specifically protecting and upholding the rights of the minorities and those of the queer people. Ladies and gentlemen, I am not going to take long, and I'm not going to stand between our legal luminary here with us today to interact with you, answer your questions, and discuss his thoughts. And that is exactly what we are waiting for. Because the judiciary has not always been forthcoming in protecting the rights of the minorities. They have had to push. So when Nafte Johar happened, I was looking at the scenario and comparing it what we are doing today. The legislature sort of abdicated its responsibility to decriminalize a very old provision in our law. We had to look at the judiciary to do that. Today, when we look at marriage equality, the Supreme Court seems to have abdicated and pushed the burden onto the legislature, saying that it's not our job. So these are some things which are of concern to us as a people of this country. So more from Mr. Saurabh Kirpal, and looking forward to that. Thank you everyone for being here.
I would like to call Saurabh sir on the dais to address the gathering.
Professor Bedi and I both need to put the mic down to our level. And I must thank all of you, of course the dignitaries and more importantly the students who come here rather bleary-eyed on a Saturday morning. Because what precedes the Saturday morning is the Friday night. And I hope you people have better things to do than wait for me on Saturday morning and up till late. But you know, these are your days and years, enjoy it. And then you become as old as I do, and then have a cup of coffee and addressing people on Saturday morning. I'm so happy to be here at Punjab University, not only because, as my name might indicate, I'm Punjabi myself, but actually the Kirpals have a very old connection with the Punjab University. It started way back when Punjab University was in Lahore. So my great-grandfather, Professor Ishwar Das, was the registrar of the Punjab University in the 1930s. And at that point of time, he was also in charge of something called the Kinnaird College, which was a college for women in Lahore. So all of my family originally came from Lahore. And at Kinnaird College, when my great-grandfather was the registrar, had a young woman studying there, who happened to be my grandmother, who was his former daughter-in-law. So our connections with Punjab University go a long, long way. And I'm so grateful to be able to come here. Maybe not in the Lahore campus, but this Chandigarh campus is already quite beautiful. Albeit a bit tucked away the back, as I was telling Professor Bedi. Maybe people are scared of lawyers. Maybe that's the reason.
Put them in the corner.
Yeah. And maybe people have a reason to be scared of lawyers. Professor Bedi, you quoted Charles Dickens. I might begin by quoting Shakespeare, who said, one of his characters wrote, "The first thing let us do, let us kill all the lawyers." And that wasn't because he hated lawyers, though people may have reason to. It was out of a belief that if you want to entrench autocracy, if you want to get rid of democracy in a country, you need to get rid of the rule of law. And who upholds the rule of law more than anyone? The law, the lawyer, and the judges. And that is what brings us to this topic, which is rather ambiguous, thankfully. That means I can digress and go on and on and on, and no one can say I was speaking off topic. Rather like a vaguely worded question in the exam, and you can write whatever you want, and we all get full marks. So, role of courts in interpreting fundamental rights. Now, I'll speak for a short while, because I'd rather have an interaction with you. But a topic as general like this seems also to have a rather obvious answer. Well, what is the role of courts in interpreting the fundamental rights? It's fairly clear, is it not? Article 141 says that whatever the Supreme Court decides is the law of the land, and the oath of office of that the judges take to the Constitution is to uphold the Constitution, right? So the role of judges is simply to apply fundamental rights as they are. But of course, that really misses the wood from the trees in two ways. First, there is a distinction between what the judges should do and what is it that the judges are doing. The normative and the descriptive. And are the two really that different? Is it not what the judges that they should do, which should describe what they are doing, inform it at the very least? And if it is as simple a matter as applying the Constitution, how can it be controversial? How can they get various judgments? Well, the answer lies in the text of the Constitution. The ambiguous words used in fundamental rights. Words like, high-sounding words like equality, freedom, reasonableness in Article 19's 2 to 6, liberty, most importantly, in Article 21. From the right to life, the right to sleep has been found in some judgments. So these ambiguous words lend itself for the courts to mirror and change and form society according to their beliefs and their ideas and their ideologies. So I suppose that's why the courts have a varying role to play in fundamental rights. But in all of this, we must remember that the courts are tasked with upholding the Constitution. And it is not as though they can give whatever meaning they want to the words of a Constitution and say, well, here, this is what it is. It sounds like that sometimes. It feels like that. Some of these judgments you read, you wonder where this has come from. In fact, Justice Ruma Pal, a very learned judge of the Supreme Court, one of the greatest ever, once famously said in a lecture on secularism that judges treat fundamental rights like empty vessels, pouring their beliefs into it, so that each generation uses those fundamental rights differently. And that's the idea of an organic constitution, one that is ever changing, meeting the needs of the society as and when the judges find it. But that's all well and good. Those ambiguous words, I come back to it, have to be tethered to the text of the Constitution, but more importantly, tethered to the idea of what it is that a fundamental right really is. And a fundamental right is actually the structure of our Constitution, which is at the molecular level, the individual. You know, when the Constitution was being drafted, multiple different models were cited. Mahatma Gandhi, the father of the nation, wanted almost a quasi-communist kind of a system. That the state would disappear, there would be these idealized village panchayats, and everyone would live in peace and harmony in the villages. You know, the romanticization of what happens in villages. Dr. Ambedkar, who by then was in charge of drafting, would have none of this. As a person who had suffered discrimination, he called villages the den of ignorance. He wanted to move away from the idea of the village where the hierarchies would oppress rather than liberate. So it was for that reason that the individual was chosen as the atomized person who the Constitution would look at. So all our fundamental rights, Articles 14, 19, 21, the Golden Triangle, and I'll come back to that, of course, famous words of Justice Chandrachud and Minerva Mills, are all focused on an individual. And as the preamble says, that this is intended to ensure the dignity of the individual and the unity and integrity was added in 42nd Amendment, unity and integrity of the Union. The idea that you cannot as a country develop unless the individual is fully free, is liberated, has equality. So the idea of the fundamental rights chapter in our constitution is that the individual is the focus of the constitution. There are group rights. One cannot forget that. Article 30, for example, the rights of a minority to set up their educational institutions, and a few other rights, 29, etc. But at the end of it, it is the individual who is the most important. And that is something judges would do well to remember. Because when they are interpreting the Constitution and reading the Constitution, it is for them to remember that the constitutional balance drawn by our Constituent Assembly is such that they must always give primacy to the equality, liberty and dignity of an individual to ensure that they can achieve all that they wish to achieve, all that this glorious country of ours can possibly offer, must be given to each citizen equally, with equal measure, without discrimination. Have they always been successful? Possibly no. And that is why the role of the judges comes in. Again, their views change, their ideas change, but the text of the Constitution does not change quite so much. So let's take a few examples. And I'll try to focus in these three articles, 14, 19 and 21. Let's take Article 14, the word equality, as ambiguous as it can be. What does equality really mean? Is it equality of opportunity? That means everyone can sit for the same exam. Is it equality of outcome? That means everyone must have the same amount of money, which entitles some kind of taxation to take from the rich, give to the poor. Is it substantive equality or is it formal equality? What does that mean? Formal equality is that everyone is treated equal in the eyes of law without any discrimination. But substantive equality goes beyond that and says, well, yes, you are all formally equal, but if you start at very unequal positions, so a lower caste person, as opposed to a Brahmin, or a wealthy person as opposed to a poor person, can you really put them in the same level playing field and say, well, here, have equality and bye-bye? At that point, the courts have to step in and say substantive equality. And the judges have not always been consistent, and their ideology has changed. So in the terms of equality, in terms of what it means to be equal, I mean, we have the Balaji case in 1960s, where the Supreme Court said that equality and reservations, let's talk about reservations because that's something that excites and interests young budding students. I too, myself, I believe wrongly, took part in the Mandal agitation. I have since changed my view. I think reservations are needed and very good. That might make me unpopular with some of you, but hey ho, that's my considered belief. So Balaji said that reservations are an exception to equality, stemming back from the judgment of Champakam Durai Rajan, where in 1950 the Supreme Court struck down caste-based quotas in the communal order in Madras. The constitution was then amended by the first amendment to the constitution by Pandit Nehru. Even before the elections, the first elections to the parliament happened. But Balaji, interestingly, said that they are an exception, and in doing so, gave an interpretation to Article 14, which is that Article 16 stands as a beacon of equality, 16(4) exception to it. And in doing so, also, it was not as though it was independent of the text. Dr. Ambedkar, in his speeches in the assembly, also held the same view, that the idea of reservations under Article 16(4) was meant to be as some kind of representation for the lower castes, an exception to the ideal of equality. Things move on, another 15-20 years down, and we have a judgment called N.N. Thomas. Now, N.N. Thomas is a 7-judge bench delivered by multiple judges, including probably one of the most famous or notorious, depending on your perspective, Justice Krishna Iyer. I don't know how many of you would have read judgments by him. It's fairly inspirational to read it, provided you can understand it. Yeah. And I dare say a lot of people don't understand it, but you just nod, yes, that makes sense. And answer is, it doesn't always. But that judgment changed the law a bit and started saying, well, Article 16(4) is not really an exception to equality. It is very much part of equality. That's the idea of substantive equality. That when you give reservations to a historically disadvantaged group, you are remedying injustices which are systemic and ancient. But you're also recognizing the individual position of each person. So the idea then again became atomized. The individual became the focus again of the Constitution. That your historical disadvantage will be cured by the courts. So that was a judicial shift in thinking from an idea of formal equality to the substantive equality. We move a bit further, we come to Indira Sahni's case, where this idea is taken forward a bit more, and it is now decided by a bench of 9 judges that equality and reservations are part of a composite code. And interestingly, they also said that there can be no reservations in promotions. Now that's to me contradictory, but that's maybe for a more academic discussion on sometime other than a Saturday morning. We then move forward again in Article 14, and at this point of time, Indira Sahni also settled that while equality is a composite whole and reservations are part of equality, but if you go beyond 50% of reservations, then the entire equality code will be destroyed, and therefore there is a cap of reservations of 50%. And you can't have more reservations than 50%. That rule is upheld in the Maratha reservation case, where the 10% reservation is struck down by a constitution bench. And you think, well, that's what the judges are, this is how they're interpreting our fundamental rights, this is now an equality code, etc., etc. And then, boom, comes Janhit Abhiyan, which is a judgment that upholds the reservation for 10% for the economically weaker sections. And now we find that the Constitution permits not just 50% reservation, but 60% reservations. The judgment says that there should be something like a proportional equality. We have the caste census that comes, with Bihar now giving reservations of up to 75%. So is that still part of that imagination of Article 14, where it is an equality code? Or have we moved now to a form of equality which is distributional equality, that you ultimately judge Article 14 case by the outcomes? Does everyone have exactly as much as they deserve? Jitni abadi utna haq is a phrase that some politicians have used. So that's how Article 14 has worked over the years, changing constantly in its meaning, its endeavor, its ideas, depending on the philosophy of the judges. The Balaji judgment was also authored by Gajendra Gadkar, a famously conservative man who gave all the judgments on the essential religious practices. That's the entire doctrine was really set up by him, who then ended up becoming the chairperson of the Law Commission of India and is famously credited with backing the court or trying to back the court so that the Kesavananda Bharati judgment, when it came, would be ruled in favor of the government. I would commend all of you to read a book by Kempton Nandayojana called the Kesavananda Bharati judgment. But that's different. I suppose what I'm trying to say is that judges also are human beings at some level. And when they decide, they come from their perspectives and ideas. And I might end with this point. But since I'm on that golden triangle, I'll quickly talk about 19 and 21, how the views have changed of judges. Article 19, of course, initially there was a lot of protection of free speech. So we have judgments like Romesh Thapar coming in 1950. Almost there is judgment of the Punjab High Court, since we have Punjab, I should mention, striking down sedition law at that point of time. The Constitution is amended again, and you now have a provision which permits sedition. It's now being reconsidered, of course, finally. But I find over the years, the court's protections and court's interventions in protecting free speech have become a little less robust, especially in matters of free speech. Not because they don't finally uphold free speech, that they do. I mean, we have the right to internet now recognized in Anuradha Bhasin. It's just the speed with which the courts sometimes act. If you give a judgment when someone has been in prison for making a hate speech, which is not really hate speech, but just freedom of speech, after a few years or a few months that person has been in, that stops having meaning and purpose. Other than the academic text and article that you've written, the substantive impact on the ground is less. So I find on Article 19 on freedoms, the courts have digressed a bit in society. We always have a hierarchical structure. You all look up to Shruti ma'am rightly, metaphorically if not literally. But we have hierarchies in our country. And we don't value our fundamental rights as much as we should. The idea that we can become who we can by getting our rights and asking for them, fighting for them. And that's something that is filtered in, I think, into the judiciary as well. The idea of the state being the karta and giving you your rights as manna from heaven, rather than you being entitled by virtue of being citizens of India to those fundamental rights yourself. I think there is a problem there. Article 21, on the other hand, has had a very circular and interesting move, starting from Gopalan's case, when 5 judges, 3 to the majority, that's the Fazal Ali and Mehta Majan, dissenting, saying that the majority upheld Article 22 on preventive detention and said all fundamental rights are in silos. You can't use 19, 20, 22 together in a hodgepodge and protect fundamental rights. And Article 21 cannot be used when Article 22 is being used. Article 21, as you all know, right to liberty. Article 22, preventive detention and police powers. And therefore, if you have right under 22, sorry, you can't have no rights under 21. Moves on, we have Cooper's case, bank nationalization, undoes this theory, finally recognizes Menaka Gandhi's case, saying this idea of silos is completely broken, and then starts the golden period, the renaissance of Article 21, where this vessel, as Justice Suma Pala was mentioning, is now poured in with content with all kinds of things. So we have now the right to clean air, the right to a good environment, and multiple other rights that Article 21 is. So Article 21 becomes almost like a catch-all for judges to intervene when they feel that they need to remedy some injustice. You think this is a good move, it's moving in a particular way. Article 21 is moving away from idea of rights as life to what are called unenumerated rights. Even though they're not listed, this is what the content of Article 21 is. It's a doctrine used from American jurisprudence, often not recognized even by judges who are writing that judgment as to where this doctrine comes from. But we have a great judgment like Navdev Johar. Article 21 relied upon meaningful right for everybody. And then we come suddenly to Supreo, and maybe we can talk about that at some point in the interaction. And suddenly Article 21 no longer has any meaning. They say, well, you may have certain rights, but you don't even have a fundamental right to marry. Forget the queer community for a moment and the discriminatory aspect of it. The implication that our constitution does not have an unenumerated right, a fundamental right for any two people to get married, to me is completely anathema. It means tomorrow Parliament can repeal the Special Marriage Act and a Hindu and a Muslim can no longer get married. The repeal of the Special Marriage Act would also mean that people from 2 different castes cannot get married. Because we are reverting to the ancient idea of marriage in India, you could not get married within the Gotra, of course, Sargotra weddings go, and you could not, as a person of one caste, necessarily marry a person of another caste. So, are we saying that our constitution permits that? Answer, yes, because that's what the Supreme Court has held today in Supreme. So I think there is also a bit of a drawback from what Article 21 means. And I suppose that has something to do with the views and ideologies of the judges, a political context at a particular time, because while it's all easy to say that judges are independent guardians, the fact is that they are influenced by all that is happening around them. And maybe that's a time for me to just focus on 2 more things and then wrap up. Because I said I'd only speak for 15-20 minutes, but I love to speak. And I've got a rapt audience. So, bad luck. I had started by saying that an individual is the heart of the Constitution. So why is it that judges are given this power to decide? Why is this anti-majoritarian institution of the judiciary in charge? Precisely because an individual is at the heart of the Constitution. Now, majority or a group which has political power, doesn't need protection. They'll vote. Of course, with our first past post system, that doesn't always work. You can be in a minority and still come to power. But generally, that is not the case. An individual, on the other hand, who is disempowered, who may be in a minority, who may be the subject of complete hatred by her fellow citizens, protection. And that is what the Constitution guarantees. And of course, once you guarantee a right, you must also guarantee a remedy. That famous Latin phrase, ubi jus, ibi remedium. If you have a right, you must have a remedy. It's a principle of common law, but it's also a principle of logic and common sense. So that is why our constitution makers gave judges the ultimate role to protect individual rights. Professor Dr. Ambedkar famously said of Article 32 that if any article is the soul of the Constitution, it is this. So we probably end, I suppose, maybe another two anecdotes so that I keep on getting not fooled by the audience. So the role of a judge really, at the end of the day, is to ensure that individual rights are protected. And that is how, meaning not only to the text of the Constitution, but also enabling people to live their lives fully and completely as guaranteed by the Constitution. And in doing so, of course, judges are meant to raise themselves above politics, above the day-to-day battles that are happening in society. That's not always possible for judges, because they're also human. But we come back to this idea of this golden triangle, Article 14, 19, and 21. And maybe I can focus on that one judge who came up with this idea of the golden triangle in Minerva Mills and trace his trajectory and his thinking to show how judges change as well. And that is Justice Yashwantrao Chandrachud, the Chief Justice who served the longest time in the Supreme Court. He was part of the famous Kesananda Bharati judgment, where there was a 7-6 split. He was in the minority, holding that the Constitution could be amended in any which way. So he was not the one who held that there is a basic structure to the Constitution. He luckily signed that majority order. I don't know how many of you know this, that Justice Sikri delivered the judgment in Kesananda Bharati on the day he was retiring, and there was complete confusion about what the judgment said. Not was, I don't know how many have actually tried to read the judgment I have, but I can assure you it's not an easy thing to digest, to understand what it is. So really, as kindness to the citizens of the country and to law students across the country for the next few generations, Chief Justice Sikri tried to convince all his colleagues to say, well, this is what the majority has decided, so at least 8 of us can agree on that. So ultimately, that was majority order was signed by 9 people, including 2 in the minority, which included Justice Chandrachud, who then later is said to have said that I only signed this because the Chief Justice was retiring and I didn't want to say no to him. But thank God for that, because at least we know what the majority decided. Captain Nandarujana, who I spoke of earlier, thinks that Chandrachud got it wrong. He should not have signed that, and that's not what the judgment decides. But all of that changed later. I'll finish with that anecdote. So thus, Justice Chandrachud decides this case Kesananda Bharati in 73. Few years later, in that rather infamous case of ADM Jabalpur, decides that Article 21 can be suspended during a period of emergency. So the judge is seeming to take a particular view, which is anti-fundamental rights, anti the rights of the individual. Kesananda Bharati and, of course, ADM Jabalpur. Then Indira Gandhi loses power, Janata Party comes in, 42nd Amendment is largely undone by the 44th Amendment. But one remnant of the 42nd Amendment is an amendment to Article 31C of the Constitution, which provided, and I promise you I'll end with this, and what the judge did. Article 31C had been inserted, and that said that if there is any violation originally of a fundamental right and of a law which violates a fundamental right under 14 or 19, it will not be struck down by courts if there is a declaration that it is in furtherance of a directive principle under Article 39B and C. So really the balancing act between fundamental rights and directive principles were given a primacy, but only for 39B and C. That was changed by the 42nd Amendment. And it was then said that any directive principle of state policy, a directive principle of state policy, will trump Article 14 or 19. That led to a judgment of Minerva Mills, authored by Chief Justice Chandrachud at that point of time. And it seems he had a change of heart by now. And he says that I'm entitled to change my view. And he says in a very famous passage that what this amendment has done is to take away two ends of that golden triangle, which are 14 and 19, which in Tagore's idea was how dignity of the individual will be assured. It's a beautifully worded passage. Of course, one suspects that that change of heart may also have had something to do with change of government. But the learned judge completely moves from Kesavananda Bharati and ADM Jabalpur to Minerva Mills and strikes down this amendment of Article 31C. One of the few times that the Constitution amendments have been struck down. Because on a side, they're always struck down in cases where the power of the judicial review has been taken away. So L. Chandrakumar and Kesavananda Bharati and Minerva Mills, all of these cases where they've been struck down have been when judiciary's power of judicial review has been taken away. That's when they say, no, thus far and no further. The AJC judgment. So, I suppose, again, what I'm trying to say, and I'm going to wrap up with that, is that a judge is a human being. But a judge is a human being who is trained in law and has to fulfill the promise of the Constitution, which at the end of the day is nothing more and nothing less than the right of a person to be able to live their life without fear of oppression from a majority who are baying for her blood, the ability to get a job without being taunted because we are caste, the ability to dress what you want to, eat what you want to, live how you want to. That is the idea of what a judge should do, fundamental rights. Thanks.
Thank you, Saurabh sir, for shooting us down with the constitutional law knowledge. Thanks to our professor, we could make some sense of this, but I'm very sure we'll need some more hours to digest it. But without any wasting time, Agastya will be moderating the question and answer session. So please take over.
First of all, thank you, sir, for sharing innumerable insights on the contours of fundamental rights in India. Since I'm moderating one, I would like to take the first question itself. Since you talked about the concept of ambiguity in law, so how do we import the concept of ambiguity and put it into use with regards to the conflicting interests and conflicting rights? For example, the right of a woman to profess their religion versus the right of a temple to manage its affairs. So how do we import the concept of ambiguity with regards to the conflicting rights of an individual?
Well, like a little birdie thing tells me that you might be talking about the Sabrimala case. I don't know, I just feel that maybe. We don't import ambiguity. The ambiguity is there in the text already. And that ambiguity is a tool which allows judges to decide what they do. It's also a tool that allows lawyers the ingenuity to argue different things. So in the Sabrimala case, for instance, something quite interestingly, Article 17 was used, the prohibition against untouchability. Is untouchability only that which applies to the scheduled castes? Or is untouchability also a refusal to allow menstruating women to enter into what is considered a holy place, a temple? And in that ambiguity, for instance, which an example of ambiguity is that the words when you see of Article 17 use the words untouchability in quotes, which shows that the word untouchability when used in Article 17 doesn't mean the traditional sense of untouchability, not the scheduled caste. Why using the word in quotes? And there are discussions, of course, in committee meetings which reflect and back that. But I suppose, again, to answer your question, ambiguity is innate. Balancing of fundamental rights does not require ambiguity. That is just two separate rights. The right of a temple to administer its own affairs may not be the correct provision, I think, in this one. It would be the right of a religious denomination under Article 21, which, of course, by a 4-to-1 majority, as Hindu Malhotra dissenting, she was the only one said that Article 21 is Article 29 is applicable. 4 of the judges said Article 29 does not apply. But the idea was still, in terms of freedom of religion, here is a person. Yes. So the judgment, of course, as you all know, the judgment talking of Saurabh, let's give a short background of what happened in the case. There is, and it's an interesting story actually, because the temple is the temple to Lord Ayyappa in Sabrimala. We all know that. Who was Lord Ayyappa? Lord Ayyappa was the son of Lord Shiva and Mohini. So we're talking the queer community. Here is a Lord born to two men. And he is supposed to be in Nastic Brahmacharya phase. So no person who is, no woman is allowed to go there because they might detract the Lord from his Brahmacharya. Now, of course, matters of faith inevitably are beyond logic, because faith and logic are not necessarily coextensive. Faith requires you a leap beyond logic. And if you respect faith and you respect the right to religion, you must always allow transcension from logic. So that's the right of a community to pray and say, these are my religious principles. And that is a group right, because I alluded to that earlier. The fight between the individual and the group. So the group right has a right to pray. But what about the right of that individual woman who wants to go in and say, well, just because I happen to have a physiological event occurring in my body, i.e. menstruation, and not just at that point, from the ages of 14 to 50 or 10 to 50, you can't stop a woman from praying to her God. You may have a right of the group, but ultimately the right of the individual will trump the right of the group. Because as I think the Lord is also kind of into me. I believe the Sabrimala judgment was correctly decided, where the rights of the woman were trumped the rights of the group to pray. Because if we start allowing group rights to trump individual rights, we are fundamentally altering the balance of how the Constitution works. So the ambiguity, I repeat, really wasn't there. But there are certain instances. Denomination. Does it include a sect such as the Ayappans who go to Sabrimala? In that they relied on an Anand Margi judgment, is it a sect or not? But that's again a very technical area of the law, we don't need to go in. What is an essential religious practice? I was talking about Justice Gajendra Gadkar earlier. The idea that the only thing a religion allows you to, or a right to religion allows you to foster, is the essential religious concept. So that takes you to the hijab case. Is wearing a hijab an essential religious practice or not? Where does the essential religious practice come from? Answer, nowhere. It is read in through ambiguity into the text of the Constitution. So there are ambiguities which are there inevitably, but some cases like this one you refer to is about balancing more than ambiguities. Rather long-winded, but...
Thank you so much, sir. Now I'll be opening the floor to the questions.
I think you can just start.
Yes, please. Thank you. My name is Pavit. I am from the neighboring, arguably elder Department of Laws. And it was a privilege listening to you today. Thank you very much indeed. Sir, my question is not as much about rights, but it is an elephant in the room. If you could address it. And even if you don't wish to address it, we'd understand because we have your best interests in our heart.
They're not making me. they were given the responsibility of standing up for the rights of the citizen. They chose not to. There's an anecdote of when the matter, Jabalpur, was being argued in court, and some particularly obnoxious argument was made by Niren Dey, who was the Attorney General, saying that if Parliament wants, they can enact a law to boil a person in oil, and there's nothing the courts can do about that. Justice Khanna was horrified and looked to his brother judges and said, I knew all was lost when all four of them had their head down and were just quiet. So I'm not going to let those two off as a hook so easily. I don't ever want to let judges off the hook. They must be judged fairly. There is no point just making insinuations against judges. I think we sometimes go to the other extreme. These are people who cannot defend themselves in public, and allegations are made against them, then that is unfair. But when they write through their judgments in the form of ADM Jabalpur, then I call them out, right? Or, as for instance, I will call out Justice Bhatt for superior. But that is not your question. The question was, have the judges decided to kowtow to overbearing executive in matters of judicial appointment? Well, first I would say this is not the first time this has happened. Before the second judge's case, Supreme Court Advocates on Record Association case came, there was S.P. Gupta, the 7-judge case, which allowed the government all the power to appoint judges. And that was a recognition of status quo, because that's how appointments were made all the time. The Chief Justice was appointed, but he was usually informed that that appointment was going to be made. This is in the time of Indira Gandhi that this happened. There was a very famous law minister she had, very powerful, maybe almost as powerful as some of the law officers of today, called Shiv Shankar. And that man could rule and dictate appointments. He had his Attorney General at that point of time, a person called Mr. K. Parasaran, who was also the head trustee of the Ram Mandir Trust, Ayodhya Trust. And the two of them would decide appointments completely between themselves. It was because of that action that I believe a very innovative, arguably incorrect interpretation of Article 124 came in, which is the SCO, the Supreme Court Advocates on Record Association case, giving power to the judges. But good, bad, indifferent, right or wrong, a judgment of the court has to be followed by all. That is the very meaning of the rule of law, right? Private citizens no more than government can dictate and say, well, I think this is wrong and therefore I will not follow it. So yes, today, when judges appoint and the collegium recommends a name, it is imperative on the legislature, actually not legislature, the executive, to appoint those judges. Are they failing to do so as part of fear? Well, that's something that they best answer. When no other reason comes and is evident from forthcoming, I suppose we will apply Section 114 of the Evidence Act and decide ourselves, which is, I will tell all of you to go and read Section 114 of the Evidence Act later. It's presumptions, including judicial presumptions. So you are entitled to make your assumptions. Judges will always deny that they are backing down, and they'll say, what is it that we can do? Well, when judges want to do things, they can do things. That's all I will say.
So, Sean.
Good morning, sir. My name is Trisha and I'm a third-year student of this department itself. My question, sir, is about a dilemma or a loop, I would say, that presently exists between the judicial overreach and the principle of separation of power. So recently there have been various instances with this Election Commission judgment and the Kashmiri judgment, and we've seen the Supreme Court or the various high courts tending to go beyond what we as normal people apprehend they should go beyond. But also that becomes important to to maintain the sanctity of the fundamental rights. So how, as advocates or as lawyers or as people related to the law in any way, we deal with the dilemma that exists between the breach of the judicial overreach and maintaining the sanctity of the separation of powers.
Well, at the outset, I'd like to point out that what you're talking about is part of a deeper question also, which is that it's not just lawyers, advocates, and judges who have to be concerned by this. The Constitution does not belong to us. It belongs to everybody. It belongs to the citizenry of this country. It is a people's constitution, as was being referred to earlier. There's a fantastic book by a fellow called Roland Day. I would recommend you read that. So we're all interested in it as citizens, because it is constitutionalism doesn't happen just in courts. It happens every day of our lives. So that's a valid question that you ask from everyone's perspective. In the question of then drawing the balance between overreach and activism and acting in furtherance of fundamental rights, well, that's obviously a question that will always lie in the mind of the beholder or the mind of the thinker. One person's overreach would be another person's abdication. So I take most famously the example of Supriyo again. Had the court gone and allowed for a civil union, the queer community would have said, well, this is nothing other than upholding our fundamental rights. A corresponding answer to that would be, well, this is a case of judicial overreach. Inevitably, in the balancing exercise that we talked, even in the case of the Sabarimala temple, there are competing views, ideologies, interests at stake. Judges are called to decide upon them. One side will accuse the other of overreach or abdication. And the answer is usually somewhere in the middle. A judge is supposed to take a decision from an unbiased manner in accordance with the text of the Constitution and the precedent. And yes, in instances there may be overreach. But ultimately, I think that is not the case. Because our Constitution and the structure, as I said, giving the power to judges to ensure that the freedom of the individual is upheld, requires them to go and make decisions which are anti-majoritarian, which are against what the majority wants, against what people of the country may want also. Because the individual is ultimately to be guarded by the courts. And those few, and I'm always amazed and surprised, that the decisions that the government takes, that the courts take, which are allegedly overstepping their boundary, aren't matters such constant and dramatic moment that will require the kind of opprobrium that is shed upon the judges for taking those decisions. The political pressure, the social pressure that is put upon them for taking a decision which is within their constitutional domain. It is their not only right but their obligation to fulfill fundamental rights. So they're just doing their job. So in this argument between overreach and abdication, I'm firmly one who says that the judges generally should act in favor of overreach, because that overreach is nothing but their job, and that is our Constitution. You know, we all adhere and say that the Constitution is something we believe in, right? We all believe in it. Well, the Constitution also has Articles 226 and 32. It also has Part 3 of the Constitution. So how can you say, I believe in the separation of powers of the Constitution, but I won't believe in this part, because that's inconvenient to me. That's often politics rather than law.
Sir, I have a follow-up question with one of your remarks. You said that, very rightly said, that the Constitution just does not belong to the judges and the lawyers, it belongs to the people. And when we talk about ambiguity, it also makes me think about that I think so everyone sitting in this room, we come from a privileged place, and we are in a setup where we tend to understand what the law has for us and what goes against us. But in the place I come from, and my personal experiences, the roots, the smaller towns, people there are not informed as per about the idea of the Constitution itself, about the idea of something like a fundamental right. So how do, in a place like this where there is no knowledge, there is no I would say awareness per se. Awareness is a strong word, but that is the right word. Wherein people are barely informed about something like the Constitution. How do we as advocates, as young advocates, bring them to that level wherein they can understand the Constitution or the judgments, or I say even the court itself, is not able to reach the roots. So how can we somehow, as young lawyers or people in law, like not even lawyers, like you said, just people in law, bridge that gap?
Well, partly I'll agree with you that it is quite obvious that a vast majority of India does not know constitutional provisions. They have a rough understanding, however, of what the right is. But it's not just the constitution. People across India don't know a lot of the laws, and there is general ignorance of the law. And that takes back to the point I made earlier that we are not a rights-focused society. While we have these great fundamental rights in the constitution, we don't choose to exercise them always. A flip side, of course, of that is that in a country as large as ours, we don't need everyone to fight for their rights. Given the dilution of the local standard requirement, we need only a few people to be able to stand up for the rights of the disenfranchised and the underprivileged. So Bandhuva Mukti Morcha and that line of cases, POCL. We need a few people to be able to go to court and fight for the rights of people. I had told you earlier of a People's Constitution, that book, Rohit Day. His thesis is that shortly after the promulgation of the Constitution, the people who used that Constitution most were small town Indians who approached the court with these newfangled rights, including a gentleman called F.N. Balsara, who was a Parsi in Bombay, who unsuccessfully, and sadly very unsuccessfully, sought to annul the Bombay Prohibition Act. It's tragic that he lost, because today maybe we wouldn't have some of the laws we have in Bihar and Gujarat, but hey ho. But how do we educate? Well, how do we educate in all other matters? The law is as much an aspect of one's being as the right to receive money in your bank account, the right to your ration, multiple daily travails of a person living in small town or rural India, or indeed if you are from the underprivileged lower caste in urban India. You only need to drive 5 minutes outside of palatial bungalows to see exactly the level of deprivation that can happen in our country. So it's not as though there are silos and these are isolated places called big cities and metros where everyone is aware of their fundamental rights and outside they're not. There is a general lack of legal awareness in our country, partly because a lot of the text is in English. So there is some move being made, of course, already in that to translate it into regional languages. But even if that is made, that doesn't really help if you're illiterate, right? And even if you're not illiterate, if you have some of these judgments written in the esoteric language that is employed by judges, or indeed as I'm speaking this now, hey, I'm a lawyer, it's not going to filter down to people. So what you need is legal awareness and education camp. You need legal aid. You don't expect everyone to become a lawyer. That will put us out of business in any case. But you need everyone to be able to access aid when they need it, right? Not everyone needs to be a doctor before they know about their body and ill health. They need access to a medical doctor. So that's what you need, is you need networks of legal aid lawyers, or even if you are not legal, you can be a rich person and yet uninformed. You need people who are in the legal profession who are honest, and that is our responsibility as lawyers, to ensure that we fight for justice for our cause, for our clients, and try always to do the right things. I know that's it.
Thank you, sir. Thank you.
Also, considering the paucity of time and to inculcate and address everyone's inquisitiveness, I would request everyone to kindly refrain from asking follow-up questions. Abhirali, you have to say the question.
सर जैसे एम्बिग्विटी पे यहाँ पे बार बार बात हो रही है, तो एम्बिग्विटी जैसे मैंने देखा कॉन्स्टिट्यूशन की क्लास में ही पढ़ा था कि जो पर्सनल लॉज हैं उनको टच नहीं करा जाता कॉन्स्टिट्यूशन में, लेकिन दूसरी तरफ डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी में आर्टिकल 44 है यूनिफॉर्म सिविल कोड की वो बात करता है कि ये स्टेट की रिस्पॉन्सिबिलिटी है, और गोवा में यूनिफॉर्म सिविल कोड ऑलरेडी है पुर्तगीज एरा से। तो सर कहीं ना कहीं ये फिर इस एम्बिग्विटी का रीज़न क्या है कि एक तरफ आर्टिकल 44 है, दूसरी तरफ कॉन्स्टिट्यूशन में कहा है पर्सनल लॉज के साथ कोई टैंपरिंग नहीं होगी।
एक तो it's not correct to say Constitution says that there will be no tampering with personal laws. That is the result of a very old judgment, 53, Narasu Appa, Magi, right? Justice Chagla's judgment, which said that a personal law is not law within the meaning of Article 13 and therefore is immune from judicial challenge. That is wrong. I believe it has been questioned by Justice Chandrachud, though not overruled in the Sabrimala judgment. So the jury is out as far as whether personal laws are immune from judicial review or not. Current orthodoxy, by virtue of this Anarsopa judgment, is that they are immune, but I think the days are numbered of that. But to your question of the ambiguity, again, I don't think it's ambiguity, but it is a tension. Because this was deliberately done at the time of the framing of the Constituent Assembly. Now I know that's not some people's favorite bedtime reading, the Constituent Assembly debates. But if you do soldier through it, there's a great book again by a lady called Rachana Bajpai called Debating Difference. And you will find in that a large part of the Constituent Assembly debates were focused on allowing minority community to retain its personal laws at a time of partition and riots. You must remember that you're sitting in 2023, 2024 in Chandigarh, but 75 years earlier, just 10, 15, 20 kilometers away from you, the partition of India was happening. Blood was flowing, people were being killed. The minorities in India were feeling threatened. So there was a constitutional compromise at that point of time. A promise given to the minorities of the country that yes, your right to administer your own personal laws will be preserved and protected, because this is what will enable you to get integrated into society, and this is the price we pay to allow you to feel free and be within the community. Yet it was recognized that at some point in the future, maybe with small steps, we would have to move towards a uniform civil code, and therefore Article 44 came. Directive principles, by their very nature, Part 4, as you know, non-justiciable, therefore are put at a lower pedestal than a fundamental right. So it was not a coincidence or an ambiguity that personal laws are given greater precedence than the promise of uniform civil code. Do I think the time for the uniform civil code has come? I believe it probably has. The only problem is that given the polarized nature of our society today, there would always be a lurking suspicion, and undoubtedly, probably correctly, that the reform that is sought to be brought into personal law is not only to protect the interests of women or other disempowered and disenfranchised. No one even thinks of queers, of course, in any of this. But it is as a result to put people in their place, right? So it has to be done with great sensitivity by taking people along, including people in conversations, so that the change can happen. Changes have been happening in Hindu law from 1955 with the Hindu Code bills, right? The 5 acts that came, the 3 acts that came at that point of time. But of course, you will also know, I'm sure you're a lawyer. So the process started in 1951 of the Hindu Code bill. It was then scrapped, then restarted because of the massive opposition of the Hindus in Parliament at that point of time. No less than a person like Rajendra Prasad, the first president of India, who refused to sign some of the bills. And the Attorney General was then sent to him, saying that you have no right to refuse to sign a bill, something we seem to see increasingly across states in India today. So Rajendra Prasad was forced to sign the bill by the then Attorney General, saying that you may be a conservative Hindu, but you have to sign this. Ultimately leading to Shamsher Singh, the 74th Supreme Court. Well, that's another. I'm sorry, I digress sometimes. I mention one point of law and I get so excited about it, I start talking about other things. constitutional law is like that. You can't read it. And that's, maybe I should just end with that. As a principle of constitutional law, you cannot just say, I have these two articles, your right to religion and Article 44, and let's just compare these two. It's like a spider's web. The entire constitution was a compromise enacted by the Constituent Assembly. And part of that compromise, good, bad, indifferent, given the needs of the time in 1950, 49 actually, was keeping personal laws in place. Maybe privy purses, for instance. There was money given to royal princes because that was needed for their incorporation into India. Ultimately upheld in Madhav Rao's and this case, but then undone by a constitutional amendment. So these are constitutional compromises. Times change, constitutions are amended.
Thanks a lot, sir, for your vast knowledge on the constitutional law.
Thank you, sir.
Good morning, sir. My name is, I'm a student from first semester, and my question is simply, that has a question that has bothered me since day one of the starting of this semester. So in our syllabus, we are taught jurisprudence, right? In which we are told that there are multiple perspectives to solve one problem. But what happens in the real courts is that one decision is taken. So the other side, which has a different perspective, that has to be compromised in a way. So how do we resolve that dichotomy between these two?
Well, unfortunately, judicial decision making is a zero-sum game.
Right.
One person is going to win, the other person's got to lose. This is not an academic debate that is happening, and other than lectures that judges give on seminars, the actual decision making has to take place and the judgments have to come. So that's the nature of the beast. A decision has to be taking place, and someone will lose. And that person who loses has to have faith in the Constitution that a duly established system of judges, in accordance with law, as enacted by Parliament or common law, have come to a decision, and they are then required to obey and follow it. Both the citizens as well as government. Everyone has to follow the law. That's the foundational principle of the rule of law. Be you ever so high, the law is above you. Right? The words of Thomas Fuller, ultimately used by Ganeet Narayan, in that case by Justice Verma. So the idea is that everyone is committed to the idea of rule of law. And you lose, you don't blame anyone else, as it's fashionable to now become. And now that's what alluded to earlier, to blame the judges. No, if you lose, maybe you had a bad case. And so you lost. And then if you lose and you believe wrongly, as I believe, for instance, in the Supreme judgment, I keep on coming back to that because I still have PTSD about it, then you change your legal strategy, you change your political strategy, you bring about change in other manners, but always within the constitutional scheme. It's very accommodating, our constitution, and never lose heart.
Thank you, sir.
We are the order of precedence now.
So it's a true delight that you could make time for our students. So I have one question, which is follow-up from the lecture, which is your views on the Janhit Abhiyan judgment. And a second question, which is more personal. Last semester I taught law and social transformation. I've had kids come to me and teary-eyed because they're so disillusioned at this point how to change the world. If you could give them some words of hope, or maybe show them the way, something from your personal experience, how can they use their education to change the world around them?
I thought there were no follow-up questions, but that's all right. Be you ever so high, the teacher is above you. Sorry, I jest. But Janhit Abhiyan. So, 103rd Amendment to the Constitution of India, the 50% reservation limit is breached, 10% reservations now given to economically weaker sections, other than the fact that scheduled castes and tribe and other backward castes are not included in this 10% reservation. The matter is carried to challenge. There are multiple problems with this piece of legislation. First, can you say that economically weaker section is a caste or a group or a community worthy of reservations. To which your question will have to be determined by what is the purpose of reservations. Our constitution has divided Article 15 and 16. So let's focus on 16, which is employment. And the idea was that it is meant to give representation to people. Are we saying that members of the economically weaker section need to be represented in parliament or in government jobs? Probably not. They may be historically disadvantaged, but they don't need representation the way a scheduled caste person needs representation because of societal backwardness. You know, we have had reservations in our country from 1950 till now. We have not yet had a single scheduled caste cabinet secretary. So it is the castes which need reservation. I don't believe an EWS is a category in itself that requires, particularly because that will include upper castes. So we're actually saying that an upper caste Brahmin person who is from the economically weaker section deserves a seat, but not a scheduled caste person who will be slightly wealthy. So I think the judgment was wrong on both these counts in including EWS, in which there is unanimity. Of course, unanimity in Article 15, but not Article 16. That's the end thing. The unanimity generally that there could be a cohesive group, but there was a 3-2 split, Bhatt and Dalit dissenting, that EWS quota could not exclude the scheduled castes and tribes. And I think at least if that minority had been the majority, I could have still lived with the judgment that yes, you have economically weaker sections who are entitled to reservation of the group, but you must also include within that scheduled castes and tribes, because then you're adding a double whammy to the societal injustice that scheduled castes and tribes fall within. So that's my view on the Janata Abhiyan judgment. It's wrong. What do I say to disillusioned students? It's your nature and job to be disillusioned. When you come into the world, you don't know anything. You learn all through your life, and then you come to university, and virtually every university student I've ever met is disillusioned about something or the other. Because you have hopes and you think you can make the world a better place. Right? So use that. Because the answer is, in a country like ours, we can change. We can make India a better place. You won't always get what you want. I mean, you can't always get what you think is your due but I can assure you can come a long, long way in achieving that justice. And even if you don't, just that process of trying to achieve justice is very deeply fulfilling. And I speak from my personal experience. I come from immense privilege. Not only was my great-grandfather the registrar of Punjab University, my father happened to be Chief Justice of India. I grew up in a wealthy household, from the upper caste, upper class, upper everything, other than height, I suppose. Other than the fact that I happen to be gay, right? And at that point of time, all my house of privilege in certain ways came crumbling down. And that happens to a lot of people. Women, religious minorities, lower castes. But when I fought and I started fighting for the rights of the queer community, I found solidarity within the community. I found solidarity beyond the community against other subaltern, disadvantaged, and disempowered groups. I also found solidarity with the empowered, the allies, the people whose hearts and minds I think I changed just by living my life and fighting my fight. So please go home with the knowledge that you think you are irrelevant and you think you're inconsequential and you think you can make no change. But just by the sheer dint of perseverance, as we talked about earlier, and the ability to live your life as freely and openly as you can, to the moral ethic that you think you ought to, you will bring about change. Maybe small changes of people around your small circles of society, your friends, your family, your neighbors, your uncles, your aunts. But that's how change happens. Change is not always revolution. And nor is revolution very good. Because often tends to A, attract a lot of blood, and B, rather short-lived. What we need is a genuine social revolution which takes its time, which is slow-paced with hard work, with everybody working together with the belief that we can move on to a better place, as promised in the preamble.
Thank you, sir. Continue.
A very good afternoon, sir. My name is Kanashka, a third-year student. As you mentioned that fundamental rights are empty vessels into which each generation must pour its content in the light of its experience. But sir, the question that bothers me is, what if the rise in litigation to interpret fundamental rights, can there be a situation where this vessel starts overflowing? And secondly, should the court limit its role in interpreting the fundamental rights, maybe by assessing the impact on the judiciary of such interpretations?
I suppose what you're referring to is the fact that our courts are clogged, and if that cup runneth over, then they will be unable to cite other cases. So that's a technical problem that is upon not just the courts but also the executive to resolve. The answer to the question answer to the problem that the courts are overburdened doesn't mean we stop filing cases. That's like throwing the baby in the bath water. Right? What that requires is institutional reform to increase capacity. We need capacity building. We need more judges, we need more courtrooms, we need more lawyers. That is the answer. The answer is not, well, since we can't enforce rights, let's not have any. I think that's slightly counterproductive. So that's the short answer to that. And will that vessel overflow? Well, again, that is that question that your friend asked earlier about the balance between overreach and application. One person's overflowing is another person empty. Glass is, half empty, half full. So I don't think our courts have gone so overboard in protecting fundamental rights that I think that we feel that politicians have no role. I don't think that is the case. There's a role for that.
Thank you for your insight. Good morning, sir. My name is Aval. I'm a third-year student. Whenever we have any debate on the legalization of same-sex marriage, there's one recurrent argument that we come across. That is that the society is simply not ready. How do you, as an advocate, deal with that?
Well, luckily we live in a country governed by the constitution, not by the society. So society is not ready for many things. Society was not ready for widow remarriage. Society was ready for sati. Society is ready for dowry. It still happens. That's not how a modern democratic, sovereign, social, secular republic is meant to work. It's meant to work as per our fundamental rights. So it's correct. I think society is not ready for it. And that is maybe the role of the law and the judges, to be a tool for social change. To bring, as Justice Chandrachud said, Junior, in Navde Johar, that the Constitution has within itself the possibility to perform a cathartic act. It can bring about change. Because ultimately it's constitutional morality and not social morality that matters.
Thank you, sir.
Very good afternoon, sir. I am Mohit, I am PhD scholar. And sir, my question is not related to the constitution, because we have, sir, we can ask him anything.
Why did you call me?
I'm coming to the question, sir. I'm coming to the question. So as you are, sir, as you are best version of human living to legal field, epitome of knowledge. So when, sir, you were at the age of 25, 26, where were you, what were you thinking? And what it takes to become Mr. Saurabh Kirpal? My question is that.
25, 26 was a long time ago. Given that I'm so old, casting my mind back that far requires considerably more mental gymnastics than I'm used to. The Constitution is easier than history. But I think the one thing I've always been, and I think that's the one thing all law students must always be, is in love with the law. I love it with a passion. I read law, I breathe law. I constantly was in the library. Reading and reading and reading. There is no substitute for it. As and when you pass out of law school and you will start a corporate jobs or whatever else that you choose to do, you'll have lesser and lesser time to do academic reading. You'll be caught up in the daily nitty-gritty of just trying to live, trying to get the next meal maybe, or trying to organize things for yourself. But don't lose your passion for the law. Don't ever forget why you started. And for me it was that. The fact that I always, and I still do, constantly read whenever I can, whenever I have a moment. I'm just sitting with my books, on my iPad or wherever else, just reading and imbibing, realizing with each extra book that I read, how less I know. How little I know, how much more there is to learn. There's a famous joke about, since you're a PhD scholar, about a bachelor student coming out of college and saying, well, hey, I know everything. Then goes into the masters and realizes, actually I don't know everything. And then does the PhD and says, I don't know anything, but no one else does either. Right? So maybe that's what it is. Realizing that how little you know, that thirst for knowledge and hard work. People see senior counsels standing up and in 30 seconds making a point, thinking, well, it's just face value. It's not what you know, it's who you know. And these kind of, I hear these comments, not realizing the amount of effort that has gone into preparing that brief. Not only for that particular brief. We come and make a glib comment. We speak well, lawyers. It's our training. So you think that, oh, there's just gabbing. But that gabbing has a lot of hard work behind it, substance. And there is just no substitute for it.
Thank you, sir. Mr. Rao.
Good morning, sir. So my question to you is, what is your views on the Dr. B.R. Ambedkar's, he gave undelivered address, which was later on published in the book Inhalation of the Caste, especially in the light of Janhit Andolan and Maratha subcategories and the caste-based census that is going on in Bihar. So what is your views on this radical idea that was given by Dr. B.R. Ambedkar way back, and it is quite radical for the times to come? So is it feasible?
Well, annihilation caste, of course, he was called by the Mandal to come and speak. He was then disinvited because he gave his speech, says, this is what I'm going to say. He then publishes that annihilation of caste. It's beautiful, beautiful speeches. I recommend everyone must read it. If you have not read Annihilation of Caste, you have not understood what India was and still is. There's an annotated version of that Arundhati Roy called The Doctor and the Saint. I would recommend you don't read that.
Then I'm doing my PhD on that.
All right. Well, don't read. No, a lot of Dalit scholars have commented on that negatively because to juxtapose Dr. Ambedkar and as the doctor and Mahatma Gandhi as the saint is an error because it devalues and diminishes and fails to understand the Dalit experience, what Dr. Ambedkar was talking about. And this excessive focus on Gandhi, and of course the great debate in the Pune Pact, as you of course are aware, when he said in Yerawada prison that I will go and pass to death, we don't want any reservations for separate electorates for the untouchables and the scheduled castes, even though the same time their separate electorates came for the religious minorities, the twin electorates. So that is why the fight between Dr. Ambedkar and Mahatma Gandhi became so well known, because the Pune Pact, ultimately Gandhi had his way. But annihilation of caste, well, Ambedkar was truly a legal genius. But he also said at the end when the Constitution was written, saying that I was just a hack. I don't know if you read that part. And he said that I did not do everything I could do. But to him, I would say, if he's listening, is that I think he did a brilliant job for a constitution that has endured 75 years. It is not easy. We live in a country surrounded by others where the constitutions have failed spectacularly shortly after they were promulgated. And secondly, that all decision making is compromise. You don't become a hack because you don't get all that you thought you would. He managed to get reservations for the scheduled castes and tribes and backward castes, something which is of deep meaning. The idea of the temporary nature of reservation for 10 years was carried on even now for political empowerment by reservation constituencies. Contrary to the Pune Pact. The Pune Pact gives separate electorates to minorities, but not to the scheduled castes and tribes. But our constitution, when it comes in, because Dr. Ambedkar is there, reverses the situation. And now minorities don't have any reserved constituencies, but the scheduled castes and tribes do. So he was tremendously successful. But what he ultimately believed in annihilation of caste, as you would no doubt have read because you're a scholar, is that it is not achievable through just the agency of the law. For him, for instance, the most potent way of annihilation of caste was intermarriage. Right? He says nothing will remove annihilate caste other than intermarriage, not interdining. So, for instance, Mahatma Gandhi's big thing was interdining. He believed those were tokenisms. So, intermarriage was his way. And yet we have Supreme today, which says that marriage is not a fundamental right and could technically not have a fundamental right to marry between different castes. So I think today our Supreme Court has gone contrary to the ideology and the vision as manifested very clearly in Annihilation of Caste. It's a short treatise, please read it.
Thank you, sir. Mr. Ram.
Firstly, I would like to just take this opportunity and say how elated I feel with you sitting here, because I remember in 2018 I was sitting in the same court idealizing you and Nanikar and the team and like all of my juniors. So I'm glad they are also getting to witness the brilliance of your thoughts and views, which I have witnessed in Delhi and knowing you personally and professionally. Thank you for that. Secondly, since Agastya has barred the follow-up questions, so I would like to put a two-leg questions. Sharing your PTSD on the marriage equality case. My question is firstly that it's a rhetorical question, but I'd like your views on that. Do judges know that they are also we the people? The Constitution has given. So why I say that? Taking two quotes from two of our legal luminaries who have recently said, one Justice Cole said that we can't be the opposition. We can't be made the opposition. The country people want us to make the legislature, and we can't be doing the job of the legislature. But judges can't be made the government or the opposition. They are doing their job irrespective of whatever questions they put to them. Second view was of Justice Honorable Justice Chandra, saying that quoting that I like to disassociate myself with the judgments I have after I have passed them. So can judges really disassociate as human beings also, like you have put them, after having passed the judgments, and especially judgments which encompass such vast impacts on the population? And secondly, coming to the second leg of the question is regarding sensitization of the judges. Like we have brilliant minds like Justice Venkatesh in Madras High Court, and who have themselves not understanding the queer rights in its entirety, gone for to psychologists and to therapy to understand them, and then coming to it. So what is the inherent need of sensitization of judges in the current era?
Given the norm that two questions can't be asked, and being the enforcer in chief, I'll give you a composite answer to the extent I can. Justice Cole's point, I think, was sometimes the opposition has not pulled its weight and is expected, people expect the courts to do that. And therefore, when judgments come, which are within accordance of the law, but not within the desire of a political way of being, then judges get blamed. I think it's right in saying that, is that political action has its place and judicial action has its own place. Judges are supposed to decide on fundamental rights for the individual. It is because precisely that they take political decisions in certain instances that there is a pushback. And that, I think, is dangerous. So I think that was a wise decision. To the extent that Justice Chandrachud says that he is not bothered by a decision. Well, that is the judicial ideal of Lady Justice blind with a scale in her hands and saying that I will give without fear or favor, affection or ill will, as the constitutional oath of office says of the judges. But I think that is idealized to an extreme. I do not believe it is possible, nor is it desirable for a judge to be immune from her or his social milieu. And that is precisely why I presume that the same learned Chief Justice says that we need diversity in the judiciary, we need adequate representation of women, because they bring different life experiences. Well, if you forget your judgments after they're delivered, then surely what is the need for diversity? The idea is we realize that the act of judicial decision making is not divorced from who you are. Your values, ideas, and ideals will inform to a large extent the content of your judgment, which are in turn shaped by your upbringing and your thoughts. And that is why we need diversity. And even if you can't have diversity, that leads neatly into your third point. I love point 1, 2, point 3. Is judicial sensitization. Now, if you don't have many women judges, if you don't have many queer judges, then what's the next best thing? The next best thing is training. There's a great judicial academy at Bhopal, and I was speaking to some retired Supreme Court judges who were telling me that there was a time 15 years ago that judges used to go there constantly and be educated because they were willing to believe that they did not know everything. You know, they knew that we call them my lord because it's a British tradition, not because they're gods. That has stopped apparently, and judges of the Supreme Court now go to high courts across the country rather than judicial academies. So I think there is great need for sensitization. And I'll just end with an anecdote about sensitization and how it can happen. When the NAS Foundation judgment came in 2009, first decriminalizing Section 377, that was preceded by an endeavor to sensitize. Justice A.P. Shah of the Bombay High Court, when he was the Chief Justice in Delhi, gave the judgment along with Muralidhar. When he was in Bombay, Lawyers Collective and other organizations, peer organizations, used to get Michael Kirby, who was a very famous Australian judge, who was gay, to come to Bombay and courts across the country, along with his partner, and give lectures. And these judges were breaking bread with this very well-known, established jurist who happened to be gay. And other than what the person may have said, the learned judge, I was not there in those meetings, I have no doubt that the sheer act of interaction with a person who's gay, as your equal, co-equal, maybe your perceived intellectual superior, must have made them more sensitive. So that is the reason for judicial diversity. It's also important, and sensitization. And that's why I think the NAS Foundation judgment came.
Thank you, sir.
Good afternoon, sir. My name is Supreet and I'm a member of faculty here. So my question is, sir, in context of Navdeep Singh Tawar and Supreme Judgment, do you think that during those cases there came a time where you felt that this is not a legal battle anymore, this is a battle against prejudice? Or in context of Sabrimala, then how do you react that, okay, this person is making this obnoxious argument, logic cannot appeal to this person, I'm not going to win this through logic. Then what do you do as a lawyer? And second, as Saurabh, the person, what were the sentiments at that time?
Well,
I would, sir, just want to add into this, that as a human, not as an advocate, when you were arguing this case, what were the emotions, or what was the, because it's a very personal question, you can obviously skip it, but I just want to know, we both actually want to know, so we decided together.
and you both wearing pink, so I'm
So is the worthy director, so yeah. Yeah, so we both just want
Pushy,
to know.
actually.
Yeah. So as a human being, what were the emotions, and because you were balancing the logic, the law on one side, and your personal emotions on the other side. So that you're very curious.
I just want to add one thing. When I went class to class announcing that we're going to have a special lecture, there's one statement that you made. You were having the debate with Judge Jay Saidipa, and it was the 16th minute of the debate, where you say that when somebody is homophobic, that I don't look at the person as homophobic, I look at the merit of their argument. And I kept telling students when we discussed Amartya Sen, that even prejudice rides at the back of some kind of primitive logic. I don't know why I'm getting so stirred, but their question made me think of that. And I just want to take this opportunity to thank you, because I think that was truly inspiring for me.
When we are teaching students, we also need that insight. Yeah. Because sometimes as students, as faculty members, there are situations when a student asks us a question, and we just have to give a very nicely put answer. Diplomatic. So that's the thing. As a professional, we want to know that how do you balance, so that we also become better teachers. Too many ways.
I think
Just
teachers
fair
don't
you
stop
the other one.
speaking once they're given the...
Beware of the director. But yes, that is a personal question, and that is one that I grapple with increasingly. Maybe because of my increasing age, my increasing involvement with the cause of the community. So when I first started with NAS in 2009, I was like a lot of the students we were talking about earlier, bright-eyed and full of hope, and also ready for disappointment, and had some kind of interesting idea that somehow intellectualism alone could win in court. That is an idea that has been disabused very clearly over the years that I have been practicing, that matters in court, while of course decided on intellectual arguments, are never too far also removed from emotional arguments. It's a well-established phenomenon that human beings react more to stories than to facts and to just academic arguments. So emotion does have a role in it. But you also must not forget that you have a job to perform. That when you're arguing a court, it's never about you. It may be, and it's tough. But you have to, first thing to do is swallow your pride. You are not an important person. You are nothing other than a vessel for conveying the point that you think needs to be conveyed in the manner best possible. If that requires me to draw into my emotion and reflect that in court, that is what I do. Not because it is me, but because I think that is what can win. That is my training really as a lawyer over the years, is that I move myself away, recognizing that the aspirations of millions are upon me, so it is not me alone who's arguing, right? It's not me speaking for me. And who am I? I'm but a representative. So what right do I have to put my own emotion out there? Having said that, everything that is true for a judge who decides, and I have said that judges can't dissociate from themselves from how they write. It's very difficult to dissociate yourself from that which you argue. You have to bite your tongue. But we learn that in court every day, don't we? A smart lawyer is not one who jumps up every time they think they have a point. A smart lawyer is one who holds her peace and only intervenes when you think that intervention is merited so that you will win the case. Because at the end of the day, the only goal is to win the case, nothing else. It's never about how many YouTube hits you get, how many people know you, etc. But every night I went home after that argument, and I took my clothes off, and I don't wear my night suit. I took my lawyer clothes off also, and I became me again. And at least forget Navte Johar and whatever else. In Supriyo particularly, because the stakes were so high for me personally. At this point of time, I was so involved with it that I don't think I slept for 2 months. I was overwhelmed. I was emotionally drained while arguing. They say that a lawyer who has a client who has himself as a lawyer has food for both. And maybe I was wrong to have argued the matter because I was that emotionally involved. And I thought I managed to segregate myself emotionally from the day-to-day arguments that were happening by the stupidity of what some of the arguments I felt were coming. I think I managed it, but I also think it is important for the court to see us. For the court to put a human face to the enormity of the decision that they were taking. That they could not retreat behind the abstractions of the law, which of course they ended up doing. But at least we made them uncomfortable while they're doing it. So that was important for us to be there front and center, every day in court, reminding them that these were real people and real lives. So part of my functioning as a lawyer there was, of course, also emotion. I was required, we were discussing earlier in the room over chai and discussions, that lawyers are also actors. If it was so easy to know what the law is, we could all give written briefs and give it across. But you are, at the end of the day, convincing another person about the merit of your case. And a large part of that is appealing to them emotionally at some level. Intellectually, of course, but it also involves appeal to their emotion. So maybe, because I was a queer lawyer, I was uniquely qualified to do that. That when I spoke with an authenticity that they could not question. But, my God, it was difficult. And after the judgment came, I and my other friend, you mentioned Arundhati and Menaka, we almost had a support group speaking to each other every day. The day the judgment came, some of these young lawyers came and we almost, felt sad together. But ultimately, that's how the community develops. And ultimately, to your question of how to be a better teacher, as I said, I realized I'm a lawyer first, and then anything else. You have to remember that as well. You're a teacher first. It's not about you, ever. It's always about someone else. And as long as you're aware of that, and your responsibility towards the future generation, that is what curtails you and restrains you. We all love to speak. I love to speak clearly. But sometimes you have to shut up. Like now.
Thank you, sir. One concluding question from Mr.
Good morning, sir. My name is Akshat Pathania and I'm practicing law at the Punjab Haryana High Court, sir. So my question to you, since I've understood the personal insights of yours while working on the Supriyo case, I wanted to understand your legal strategy going forward in this case. My question stems out of my primitive understanding of the judgment. I find it difficult to traverse the obstacle that has been posed by the Constitution bench in the sense that they're unequivocal, in the sense that there is pattern discrimination in the law. They all accept to it. There is an unequivocal acquiescence to that. Now my question to you is that they take the abdication of judicial responsibility was taken in the sense they hid behind the fact that there is separation of power. We can't go beyond our constitutional mandate in the sense that we can't legislate. So if at all there is a legal strategy going forward in this case, how do you plan to traverse that obstacle?
Right. That's usually a good way for it to be last question, how to look forward, right? Look ahead. I think the Supriyo judgment, for all its flaws and faults, has given us a very good starting block for future litigation. The recognition of the fact that there is endemic discrimination against the queer community has not resulted in a judgment which recognizes queer marriage because of multiple reasons that the court says. But what the court does then is to leave open the route to go on a case-by-case instance to remedy the discrimination. I no longer will have to go to court and say, well, look, there is discrimination. Well, the Supreme Court Constitution bench has already said that there is. So rather than getting everything in one go, we will go to court on a case-by-case basis. That's the first way. Second, I would say is that even though dubious as it is, that the solicitor said that a committee will be formed. Well, let's call that bluff, and we'll say, all right, form that committee. We are seeing now increasingly with the move of the Uniform Civil Code. The gentleman earlier had asked the question about UCC. It's coming in Uttarakhand. The text is not available. There were rumors that live-in relationships will be mandatorily have to be registered. That will have an impact on queer couples. That at least there will be a recognition of registration of a queer couple. So once that law comes in and fails to recognize queer relationships, that would then be amenable to challenge, even within the contours of the Supreme judgment. So since some countries increasingly moving towards the Uniform Civil Code, as I believe it is politically, that will be offer another avenue for us to bring about change. Third, as Rahul was talking of Justice Anand Venkatesh, his deed of familial arrangement, the idea of moving from marriage from status to contract, that's an important belief, right? That as a society develops, you go from status to contract. Though of course, whether that's truly the case or not is a matter for debate, because given the enormous unequal bargaining position of the two contracting parties in, say, a heterosexual marriage, you say that you move to contractual statuses. Not. But either which way, the mere recognition or having a judicial or a state imprimatur to a couple coming together through this DFA is a great thing. Fourth, he is also pushing for a recognition of queer policy, LGBT policy. So I think a lot of the change that will come in the country will be from the south, which is already ahead of the north of the country, or indeed the east and the west, in matters of queerness. Fifth, and that's something I'm sorry to say I'm in a place where I see a great violation of, a recognition of queer couples to live together. All five judges, including Justice Bhatt, says, while there may not be a right to get married, there is a right to a relationship, a right to cohabit. And that is manifested, I suppose, in a judicial commitment to ensuring that a couple of the same sex or opposite religion, when they run away, are offered the protection of the laws through habeas corpus petitions. I'm seeing in Chandigarh some instances of a violation of that judicial promise by courts. I hope that will be remedied. Certainly that is not the case across the country. Other high courts have been very interventionist. The Delhi High Court in particular has been very good about protecting rights of queer couples who are running away. As society changes and time goes on, the problems facing the queer community will change. Our legal battles and strategies will also have to change. What will also finally have to change is people like me giving up and younger people like yourselves in the audience here taking over and fighting those battles. I'm slightly tired now. I'm getting on in age, I'm getting on in ideas, and we need fresh blood, fresh ideas. We need more people to come out, ultimately, in the profession. We need the bar to be an inclusive place. We need to be inclusive not only to the queer community, but to women. The abysmally small number of senior counsels who are women in the profession is a source of great concern. Forget judges, right? What about the daily task of being a lawyer? Why is it so difficult for a queer person or a woman to do well in our profession? So that change also needs to happen. And for that we need allies. So much has to be done. I mean, we can have another 1 hour discussion on the future of the queer community and place in the law. But then maybe I'll come back to Chandigarh in warmer weather.
So I'm looking forward to it. Thank you so much for your insights, and your career and your knowledge is a testament for a lot of young lawyers myself to emulate from and to learn from. Thank you so much.
I'm really sorry we can't take any more questions. We have already overstepped the time. But we can have an informal book signing event if sir permits.
I've come here just for that.
After the short break, obviously.
Not book signing, just to meet you people.
So I'd like to call upon Professor Ratin to give the closing address for this event.
Friends,
from the questions and the queries which my younger students and my faculty members has raised. And probably some of the queries was that there is a ambiguity in the Constitution. And being a student of Constitution, I always say no. The Indian Constitution is one of the best constitutions. Why this is the best constitution? Because it is a constitution, as Mr. Kirpal said, this is something which is organic, which is transformative constitution, which is living constitution. And once a document or an institution which is living, it takes along within its fold when it progresses, when it moves with the times. So constitution moves with the society, wherever the conflicts comes, and these conflicts come in the fold of the constitution. So there can never be ambiguity in the constitution. The second thing is, Mr. Kirpal has opened the dissertation with the 3 chapters while giving a reference of Golden Triangle. And the 3 chapters are really very interesting. As far as the equality is concerned, he has referred about the work, the thought process of Dr. B.R. Ambedkar, and along with Article 15 and 16. Because equality is just not only an equality which is a documentary. Equality is to be very social, wherein each organ of the society enjoy that spirit of equality about which Mr. Kirpal was talking. And moving further about Article 15 and 16, when he said that some reservation is given. And certainly reservation is not an exception. This is an instance of equality. Because these are the instances which the legislature has taken to upward to those downtrodden peoples, those who are backward, those who have not enjoyed the fruit of the Constitution. So these are just instances. And apart from this, moving to Article 19, when he said about freedom of speech. And friends, Honorable Supreme Court's role is so much prominent that they has opened up the new type of jurisprudence on Article 19, talking on freedom of speech, which contains to be silent also. And moving further, Article 21, wherein Honorable Supreme Court, while interpreting this article, they have introduced feministic jurisprudence, environmental jurisprudence, social jurisprudence. I cannot find out any field where Honorable Supreme Court has not narrated and given the observations. As Sir said, with reference to Article 14, 19 and 21, it seems that this is a Renaissance period. But I feel, sir, this is not a Renaissance period. This is a rather post-Renaissance period. And this is due to the interference of Honorable Supreme Court. In the Supreme Court, where the advocates, the lawyers are like you, secondly, the legal education, the legal profession has very bright future. Sir, your deliberations, your observation as far as the role of the Supreme Court is concerned in interpreting the fundamental rights, it's really thought-provoking. And earlier when the lecture was started, I thought it will be a little capsule for the day. No, what I observe is this is a dose for the week where we can deliberate. Thank you very much, sir. On behalf of University Institute of Legal Studies, from the behalf of students and my faculty, from the Court of my heart, we are really thankful to you and the team of lawyers. Thank you very much.
We'll be taking a short break of half an hour, 45 minutes. Meanwhile, you can buy the books at the main.
Just chat with you don't have to buy anything.
It's not a break.
Yeah. So
there's no need to buy books, I'm happy to chat with you. It's not like a ticket.